we are going to summarize today. Any question, we are going to do the ghosts of exparte matove, rules of consideration. Those ones, I'm sure, in this video at least we shall do them. On top of that, we shall do the other questions that you want us. We start in 4-5 minutes. Yo. I'm sure we shall tackle the ghosts of exparte matove. I'm also sure I will discuss the rules of consideration in this video, then in this live broadcast. Then the other questions. So when you join, just put in any question. Understand some teams are going for exams, so just write any question I see there. But at least I'm sure in this video we shall cover the exparte matove, the ghosts. Are they still alive? Do we still experience them from the time up to now? And then we shall also discuss the rules of consideration in this video. And today, I should be able to do a video later in the night about the rules of consideration. We start at 2. We start at 2. We shall start with the rules of, let's see, let's start with the exparte matove or rules of consideration in a few. Shall we begin with one of those ones? Okay, thank you, Engineer Elijah. Elijah, what water? What water comes, Elijah? Okay, we begin with exparte matove. It's 2 sharp. We have 2 hours. Let's begin with exparte matove. Uh, in the first year, you must appreciate this principle. If you don't appreciate this case, it becomes a challenge because this case is applicable until today. So everyone must appreciate this case. The commissioner of prisons versus exparte, matove. First and foremost, we must appreciate that this case happened okay, thank you. To this bit. Rejata. Okay. Sorry, we have a technical thing we are sorting here. That's why I'm taking long to start this video. But in a few, just something technical. Okay. I think we are now about clear. We are clear about this. Let's now start this. Thank you. Okay, so this is a live broadcast that we have every Sunday. We are going to do the rules of consideration, and we also do the ghosts of experte matove, and then the next that we shall be doing will actually depend on your questions. Yes, Mr. Jacob, thank you. Just send in your questions, anything you want us to discuss. Send your questions, but let's begin with experte matove. If you don't appreciate this case, it will become very difficult and hard for you to appreciate most of these principles. So we urge you to first appreciate this case. Now, when it comes to experte matove, we must first appreciate this principle and know where does this case come from. Now, a background of this case is the 1966 attack on Rubini, where the Kabaka of Buganda Mutesa was exiled. We are trying to establishing the background of the exparte Michael Matove, the ghosts of the exparte Michael Matove. Now, when they ask you about the ghosts and they are saying, do they still exist? Give us a brief background. A background on how or what transpired in the case of the experte Michael Matove. But I want to pick, I'm assuming everyone now knows about the case, but I want to pick the take home that you must have picked out of this case. Now, a brief background of this case. When the Kabaka of Uganda, Mutesa, was exiled by Obote in 1966, which we call the attack on the Rubiri, the Kabaka crisis of 1966. The Baganda started. Thank you, Abib, live from Nairobi. Senior Counsel Abib, thank you so much. Now, the Baganda immediately started to revolt, to demonstrate, because their Kabaka had been exiled. Now, among the people who were revolting, of course, many things happened in 1966. People like Abu Mayanja Kachama said they will never cut off their hair until when the Kabaka is brought back. Yo, Amani, thank you very much. Now, people like the Amani, thank you. People like Abu Kachama Mayanja said we shall not cut our hair until when the Kabaka is brought back. You understand? So there were a series of demonstrations. Now, among the people who demonstrated was Michael Matove. Michael Matove was a Saza chief of Wudu. Those who come from Wudu. Was a Saza chief in one of the counties in Uganda, which is called the Wudu, where these days commonly known as the Banamasaka. Now, Michael Matove revolted Hi, I'm Apostle from the... Yes, Mudu, thank you, Apostle from South Africa. Atukonza Chirunja, how do you answer? Means regime. Okay, I'll get there in a few. Now, Kumba Mariam. Yes, my friend, now Kumba. How are you? What's up, Mariam? Okay, now, in this video, I'll discuss exparte Matove briefly, and then rules of consideration. Then I'll get to your question to see me from you. Okay, thank you. Now, let's now enter straight into this exparte thing. Now, Matove, exparte Michael Matove, revolted, was demonstrating, gunning people to demonstrate against the government that was coming to place. So when he started that, he was arrested and taken to Masindi port, arrested from there. But they realized he was released. But when he was released, overnight, they passed a law, a detention law, bylaw, overnight, such that they can arrest him again. So he was arrested again, whisked around and taken to Luzira. Now, while there, he contacted his lawyers. Okay? But among the issues that, thank you, Shan, among the issues that the Matove was trying to raise as a person, not in the lawsuit which was filed. Colleagues, listen. Matove was revolting, was organizing people to revolt against Obote's regime, simply because he was saying that Obote regime came in power in an uncouth manner, that they were not supposed to be in power. This is what Matove was prophesying in his demonstrations. That even the 1966 Constitution, which you call the Pigeonhole Constitution, it was not a right constitution. Now, when he was arrested and his people didn't know where he is, the lawyers applied to court and they were applying for a writ of habeas corpus. Scholars say that the lawyers who applied on the case on behalf of Michael Matove, exparte Michael Matove, that they were very vague, that for them they requested for a writ of habeas corpus. But because the judges knew the tension, what was going through, they decided, this is where we say that substance over form. They looked at the substance and said, we shall handle this suit, but we are going to address these issues. One, the validity of the government and the validity of the constitution. Because it was an issue amongst people. So when we got this case of experte Michael Matove, the judges decided to say, let us handle these two issues. Now, they handled them and they applied two principles. The Kelson theory, Hans Kelson theory, and the political question doctrine. These are the two theories that were established by the judges in this case. So, the contestation in this case was that the government of Obote had come wrongly into power. So the court were establishing what happens if a government comes to power with a coup. Now, this is your take home. What happens if a government comes to power with a coup? So court applied the Hans Kelson theory. And he said that because the Kelson theory says that the law does not seek to tell you what to do, but where you find the law, you just follow. So court observed that when there is a new order, we don't question, we just follow the new order. The only constitution was overthrown. We now have a new constitution. Just follow. And that's what the rule says. And I'm a law student. You are 271. I really enjoy it. Thank you. Thank you, Pro. Now, let me repeat this. In the case of experte Matove, what they are telling us, there were only two issues. Number one, that when there is a new order, we just follow that one. We don't focus on the old order. For example, God forbid, if President Museveni dies today by assassination, and the person who had assassinated President Museveni says, I'm now in power, courts will not question how he came. That is the new order, we just follow. But there are reasons why court is saying that we don't interfere in the new order. We don't question how did these people come. There is a reason behind why. And this is what your lecturers want you to appreciate. That courts feared that if we encroach on how this government has come, if we begin to intervene, to question how this government came to power, the people who have come to power may turn their wrath of Sungu to us, to the courts. Yet for us, we are here to protect human rights, people's rights. Where there is no judiciary, then the country is in danger. So for us as a court, we shall not interfere in the politics. That's what we call the political question doctrine. We shall not interfere in your politics. For us, we follow what has come. If you tell us this government has gone, there is a new one, we shall follow. We shall not question how this came. So when they ask you about the ghosts of exparte matove, are they still in existence? Are the ghosts of exparte still in existence? If that is the question, most of they are telling you, tell us scenarios where the courts of law have refused to interfere in politics, to interfere with the government. Tell us those cases where courts agrees there is a problem, and says, but that problem is political. For us as courts, we shall never interfere in such. Tuko pamoja. So, the moment you see the ghosts of exparte matove, are they still existing? The question is yes. The ghosts have haunted us from 1966 up to today. Let's take an example. In 1967, after this case, there was a case of Opolot, Shaban Opolot versus Attorney General, where Obote dismissed Opolot. He was an army commander, and he dismissed him from the army. Now, this matter, when it was before court, in the case of Opolot versus Attorney General Shaban Opolot, the court ruled that, the court was very clear. It ruled that we appreciate their inconsistencies. The president may not be right, but he has the right to dismiss and appoint. So we shall not interfere. Whereas we agree how you were demoted from the army is inconsistent, but because it is a political question doctrine, we shall not interfere. The president has the powers to appoint and disappoint. You see, court is acknowledging there is a problem, but if we intervene, excellent legal discussion joining you from US. Oh yes, I have Elijah from US. Thank you so much. Now, the moment, but we have gone international. People from the US watch us. This is very important. I also see my analytics here. Many watch from different countries, Netherlands, US. Yeah, we thank you so much for following. Keep following. Okay, now, you see, court in the case of Opolot versus Attorney General, court has acknowledged, mercy, court has acknowledged that we agree there is a problem with how you were dismissed by the president. But that is a political question doctrine. Now the ghosts are coming back. That is the political question doctrine. It was decided already that for us courts, we shall not intervene in those matters which are political. So the president has the right to appoint and dismiss. If he has dismissed you, it is okay. But courts have acknowledged there is a problem, but they can't interfere. That is what the case of Matove was telling us. In Matove, courts were saying, we acknowledge Obote came to power by use of gun forcefully. We saw it, we know it, but we cannot interfere. What if they turn their wrath on us? Yet for us, we are here to protect law. If they disband the judiciary, then people won't get justice. So courts in the case of Matove accepted, agreed, and said yes, there was a problem, but we shall not interfere. Let's follow the new order. So look at the case of Grace Bingira and others, and Rugumayo versus AG, where they were arrested, unlawful detentions. Still court came in and said, we acknowledge that you were arrested wrongly, but it is politics. For us, we cannot interfere in such. So you bring those scenarios where court expressly agreed there is a problem, but we shall not interfere. Look at the case of Jojo, Major General Tinyafunza versus AG, where the late now, may his soul rest in peace, the Landy professor of the Supreme Court, Justice Kenyamba, who we are going to let rest this week. Justice Kenyamba, the professor, the Landy professor emeritus, in the case of Jojo, Major General Tinyafunza versus AG, he had this to say, that for us, we cannot interfere in matters of the executive. How you run the country, courts will never interfere. But where you encroach on human rights, courts will come out and attack you. Let's appreciate this together. In the case of Tinyafunza, where he was refused to resign from the army, Justice Kanyamba, Professor, now the late, who we shall be laying to rest on Tuesday, Wednesday, preferably this week, had this to say in that case. The Justice Kanyamba said that courts will never interfere in the day-to-day operations of the executive. Let them do whatever they want. But where they encroach on human rights, courts will come out in full swing to attack them. The ghosts of Matove are now hunting us. Kanyamba is asserting and accepting that we shall not interfere in the politics. And this was the principle which was laid down in exparte matove. But where you come on human rights, we shall attack you. And he was telling them, refusing seducer from Tinyafunza from retiring from the army is subjecting him to forced labor. And that is attack on human rights. There we shall come and attack you. But where it is politics, for us as courts, we shall not interfere. Look at those judgments by Justice Sekana, political judgments. So, when they ask you that the ghosts of exparte matove still exist, yes, they exist. Courts have refused to interfere in politics, because that is what the principle was all about. So you give cases from the case of Opolot, the Rugumayo's case, the Tinyafunza case, and very many other cases. You give those cases where a decision is made in those cases. Courts acknowledge there was a problem, that is politics, but for us, we cannot enter into that. Unless you have a question when it comes to exparte. But allow me now. Thank you so much, Elijah OSP. Year 2, same one. Enjoy your business. Thank you. Learn from me. See you. Okay. Now let's cross to rules of consideration. Habib Noha from Nairobi. Thank you, Council. Mr. Jacob, YouTube Fresh. Thank you. Daddy Amani. Okay. Thank you, Daddy Amani. Yes. Apostle Muduzi Ministries from South Africa and first year law student. You have helped me a lot to understand law and how to attack questions. Very good, thank you. To go the Joe, now do you answer me? Jim, okay, we get in a few. True, thanks, sir. Okay, let's now cross to rules of consideration. unless you have a question when it comes to experte Michael Matovu, which we call the ghost. Professor Luca Onyango, in his book Expunging of the Ghosts of Matovu, clearly brings out these elements. Look out for the book of Professor Oloka Onyango, the land professor from Makerere University. I'm told the land professor retired from active teaching, but your work, Professor, we appreciate you, the land professor. Okay. Let's now cross to rules governing consideration. Let's cross to the rules governing consideration. Let's cross to the rule governing consideration. Let's define what's up. Thank you for watching. Okay. Let's cross to the rules governing consideration. I am trying to downsize these concepts for your understanding, because I know you are in a rush hour now. You're going for exams and stuff like that. So let's go to the rules of consideration. Let me first give you the definition of consideration. Section 1 of the Contracts Act, as amended, defines consideration. But let me break it for you in simple terms. Consideration means that we have two parties, that there must be loss and benefit on one side, and also loss and benefit on one side, on the other side. What do we mean? That this is the benefit, interest, profit accrued to forbearance, detriment, loss suffered or undertaken by another party. That's the English version. But if I buy a phone from my friend Elijah, if I buy a phone from Elijah, a phone is 10,000. I give Elijah 10,000, he gives me the phone. I have lost the 10,000, but I have gained a phone. Elijah has lost the phone, but he has gained the 10,000. That is consideration. Loss and benefit. The loss and benefit should be on both sides. You must give up something of value. So, I buy the phone 10,000, I get the phone, I lose the money. He gets the money, he loses the phone. That is consideration. There is loss and benefit. Loss and benefit. It is on both sides. There should be loss, there should be a benefit. That I lose and gain, you lose and gain. So when we say in contract that a valid contract must have consideration, so all parties must show what did you give in this contract. For a valid contract, there must be consideration. So, our question is, in a valid contract, what have you given? I am giving you 100 million. What are you giving me? Are you giving me land? Yes. So there is consideration. I have given you 100 million. You have given me land. Meaning that you have lost land and gained 100 million. I have lost there are 100 million, I have gained the land. That is consideration. So, when they are asking you questions around consideration, what do they want to ask you about? They are asking you, they will give you funny scenarios. But all in those scenarios, they want you to identify, was there consideration? This is first year, first semester. We are establishing a valid contract. That's why we started section 9 of the Contracts Act. All those are elements of a contract. So in this semester, we are finding out, was there a valid contract? That's all we are doing. So, when you ask yourself, was there a valid contract? It means that you tell us, was there consideration? If a question is about consideration. So where you find that someone gave the other person and the other person gave in nothing, there is no consideration. That contract is void, is invalid. A contract without consideration is invalid. If it is coming from one side, if you say he gave me, but you never gave anything, there is no contract. And that is what you are supposed to find out. That is what you're supposed to establish. So let's now cross to the rules governing consideration. But let me have your questions coming in. Also, don't forget to give us a thumbs up. Press on the thumbs up. Give us a thumbs up if you like this. Give us a thumbs up. So our first rule of consideration will be past consideration is no consideration, is the first rule of consideration. Past consideration is not consideration. What do they mean here? When they say past consideration is not consideration, this is the first rule of consideration. Past consideration is no consideration. And your examiners, I want to repeat, they love so much to ask you about past consideration and performance of a public duty. It is also a rule. These two, and then doctrinal probity, where they say the consideration must come from the promisee. Now, those three rules of consideration is where your lecturers want to ask you mostly. And I'll first discuss those three before I go to part payment of debt, before I go to consideration should be of some value. Namakanda Julie, yes Julie, thank you. You see, your lecturers want to test you on three rules of consideration. I can say this with authority. They want to test you on past consideration is not good consideration. They want to test you on consideration must come from the promisee, which is the doctrine of privity. They also want to test you on performance of a public duty. Those three rules. And then sometimes part payment of a debt when they bring in Pinot's case. So I'll discuss those four ably. Then I'll bring consideration should be sufficient, and then it should be of some value. But these four, pay attention to it. I am starting with past consideration. When we say that past consideration is not good consideration, what do we mean? Past consideration, to give you an example, let me use the one the Landy professor put in his book. That is Professor Ben Professor Ben Chinomugisha. Professor Ben, in his book, he gave a very good example that explains the past consideration. The learned professor said that if myself, I go, let's say, to the US, and I spend there, let's say, 4 weeks, but back home, I left my car in the backyard, and then one of my neighbor's son cleans my car, washes my car very well. When I come back, he tells me, I washed your car. Okay? I washed your car. So you give me something. Then I tell him, I'll give you 20,000. If I don't give that money, if he wants to sue, he cannot succeed. Because what he's claiming for is in past consideration. Why? I never asked him to wash my car. He came and washed my car. I never asked him. That was in past consideration. It is past consideration. I never asked him to wash my car. Okay, when he washed my car, what was he getting in return? Because we said, consideration, you lose and benefit. What was he getting? He never talked to me. I never allowed him. He just came and washed my car. So that is past consideration. There is nothing you are providing. He washed my car. There was nothing I was providing for him. Absolutely, there was nothing. Do you understand? So past consideration is not good consideration. Let's take a case of La Scola versus Thomas. La Scola versus Thomas. Locus classicus case when it comes to past consideration. La Scola versus Thomas. Now Thomas was selling his horse to La Scola. So they agreed on amount, and La Scola bought the horse. So the contract was sealed. So after sealing the contract, Thomas told La Scola, by the way, that horse is free from vices. After the contract had been signed, that horse is free from vices. But when La Scola took the horse proved vicious. It had a lot of vices. So La Scola went to court. And the court ruled in favor of the defendant Thomas. And said what La Scola was claiming was in past consideration. It was not part of the contract. At the time when that was said, the contract had already been signed. Meaning that, let me explain this case in simpler terms. Meaning that, if I buy a phone from you, we sign and say, I've bought this phone, I give you the money, you give me the phone. The contract has been sealed. But as I'm going, you say, by the way, that phone's battery is very good, 5,000, it will work. Now on reaching there, the battery is not working. So I sue, I cannot succeed. Because those last words you told me were in past consideration. They were not part of the contract. Had we discussed that during the formation of the contract, you would be binding. Yes, Joan Shirunji Atugonza. Thank you. You understand? Had we discussed this in the formation, they would be binding. But after the contract has been signed, whatever you say next is the past consideration. So in those problem questions of past consideration, they are asking you, find out, did these people furnish any consideration? Look at the case of Macado's case. the wife of one of the children renovated the house by painting it. Nobody asked her to do that. So later, she talks to the children, but you see, I did this. And they told her, in respect for the improvement you have done, when we sell this, we shall give you something. So when she went to court said that that agreement came after she had done. She renovated the house. Nobody asked her. There was no consideration on her own. And then the idea of paying her, giving her, came later. So court said her works were in consideration, in past consideration, she could not claim. Because at the time she did, there was no consideration. No one asked her. She was working for who? That is the question. I don't know if we are appreciating these concepts. I don't know if we are appreciating. That she, let me give an example this way. I come in this house of mine here. Let me find one of the names here. Mase. Natkunda Mase. You come to my house, let's say you're my sister. You begin to renovate. I've not asked you, maybe I'm out of the country or I'm somewhere. You renovate, you clean, you put paint, you do everything in my house. Then when I come back, I tell you, hey, this is a good job. Later, if I get money, I will pay you. Then I fail to pay you, go to court. You cannot succeed. Because what you did, I never asked you, it is in past consideration. Because we are saying in consideration is mpanku way, ofuna no firwa. I lose, I benefit. You benefit, you lose at the same time. So when you were doing this, cleaning my house, renovating it, putting all those things, what did I lose generally? Ania Kugamba, who told you? Is the Muslim. Who told you? Tuko pamoja. So that is past consideration. But still, in past consideration, there is an exception. There is one exception which I must bring to your attention. The exception is that if the request is coming from the beneficiary, even if it is in past consideration, that will be good consideration. If the rule is, if the request is coming from a beneficiary. Look at that case of Lamprey versus Brathwaite. Lamprey. Brathwaite had killed someone, and he asked Lamprey to secure a pardon for him from the king. So Lamprey started to secure the pardon. He would ride to that place. The king was very far. Talk to the king, go back. He put in a lot of effort. So later, Brathwaite promised to pay £100, which he did not pay. He promised to pay £100, which he did not pay. So when they went to court, court ruled that if the request is coming from a beneficiary, even if there is no consideration on the side of the plaintiff, then that is good consideration. Let me put it this way to make it even clearer and better. When, let's say, I kill someone, just to elaborate on that case. If I kill someone, me, tuko pamoja. If I kill someone, And I asked a friend, let me pick here, Tumusime Sad, and I asked Tumusime to go and secure a pardon for me from the president. Then Tumusime begins to move, looking for the appointment of the president. Later I tell him, I'll even give you something. So Tumusime successfully gets a pardon for me. Then I don't pay, claiming that it was in past consideration. Because remember, I have told him to pay later when he's already doing the work. I cannot succeed because it came from the beneficiary. What I was doing was from the beneficiary. And me who killed, it is me who asked for that help. So you can't say it was in past consideration. Because Tumusime has been riding to State House to and fro, that is enough consideration. So when it comes from a beneficiary, even if it is in past consideration, it will be good consideration. Let's go to the second rule. Performance of a public duty. Let me summarize this for you. Or contractual obligation. Performance of a public duty. I'll make this simple. When you are performing a public duty, you cannot say that, okay, let me begin by giving an example. If we invite you, if I tell you, come and give evidence, be a witness in this murder case, okay? You witnessed, and then I tell you I'll give you some money. Then you come and witness. But already what you're doing is a public duty. There was death. You witnessed. So you cannot claim that I've given evidence here, you pay me. Performance of the public duty. You are doing a public duty. There will be no consideration. If I don't give you money, I will succeed on it. Because you were performing a public duty. Let's take an example. You are a police officer. You are on duty. In fact, there is a case there. I forgot to it. Let me give an example. We are discussing performance of a public duty. Let me give an example. If I lose a car, and I say, whoever sees my car, I'll give you 10 million shillings. Then a police officer at the border sees the car and reports. And then we don't give him, he says his report. He cannot report. Already he was on duty. He's performing a public duty. So it's not reasonable for us to pay him because he's on a public duty. So you can't succeed when you report. You're a police officer. So in those problem questions, they will show you that so and so sold good, told so and so, you come and give evidence, or is a police officer, is a government worker. You are a government worker. Performance of a public duty is enough. You are doing your job. You can't claim for a pay. We can't pay you for doing your job. You are already paid. You can't claim that I was not given this amount. But it is already your duty. You are a public officer. You are under a contractual obligation. So that is what you mean by performance of a public duty or contractual obligation. Look at that case of Glassbrook Brothers. So look at the case of Godfrey versus Collins. Read the case of Collins versus Godfrey. That case, they like bringing that case the way it is. They just change names. Read the case of Collins versus Godfrey. Check in the book of the Land Professor, Professor Ben. Let's go to consideration must come from the promisee. It must come from the promisee. Which is the privated doctrine. That it must come from only those people who are in the contract. The contract is between me and Mercy. That is it. It is between me and Mercy. So it must come from Mercy, not anyone out of the contract. That is what we mean by the doctrine of privity. That consideration must come from the promisee. It must come from someone who has been promised. Someone who has been promised. Not someone outside. Look at that case of Dunlop versus Salfage. Dunlop sold his tires to Dew company and told Dew, don't sell these tires below this price. Dunlop sold to Dew. Then Dew sold to Salfage. Salfage, who breached the contract that of selling Dew at a price. Then Dunlop came to sue Salfage. Court held that it is Dew who can sue Salfage because the contract was between Dew and Salfage, not Dunlop and Salfage. Dunlop was not in the line. So when you are not part of the contract, you cannot sue on that contract. So consideration must come from that somebody who has been promised, who is in the contract. And then we have exceptions to the doctrine of privity, that where a third party can come and sue in the contract. The points are clear: trust, assignment, party assurance, negligence, and those exceptions show that a party who is not part of the contract can sue on that contract. Let me give an example of bills of exchange. Me, myself, Walter, I go to Equity Bank, I open up an account with them, they give me a check leaf. That contract is between me and Equity Bank. Then I come, I pay Mercy 10 million, a check of 10 million. Mercy backs the check and the check bounces. So Mercy can sue on the contract which was made between me and Equity Bank. Mercy was not there. But because I have given her a check as bounced, she can now sue on this contract. So are the exceptions to the doctrine of privity. We are discussing that a third party can sue on a contract where they were not part. Okay? Then let's look at part payment of a debt. The general rule is clear. Payment of a debt does not satisfy the whole amount. If you pay part of the debt, it cannot satisfy the whole amount. But where the request of payment is coming from the promisor, from the person who gave you that, then part payment can satisfy. and there are exceptions, which we saw in Pino's case. That if I'm supposed to pay you on 30th, and you tell me pay me on 20th, if I pay you a half of the money, that money I have satisfied the whole payment, the whole debt. Because I was supposed to pay you on 30th, but you are telling me to pay you on 20th. So the energies I am going to use, the brains, to collect some money and I give you is enough consideration to fulfill the whole debt. So if you're demanding me 100 million and I'm able to give you 2 on change of a debt, then that is enough consideration. You don't demand me anymore. Because I was supposed to pay on 30th, you asked me to pay on 20th. Okay? You asked me to pay on 20th. I have now many things to pay you that money. So whichever amount I give you on 20th is a satisfaction of the whole debt. 2, if you change venue, I'm supposed to pay you in Mukono. You now call me in Masaka. If you're demanding me 10 million, I come with you 2. The change of venue has satisfied the whole amount. Because you have put me into a funny situation. I'm supposed to come to Bukono, you are inviting me in Masaka. I now have to board Inca cost, Inca what, so it becomes a challenge. And very many others under the Pino's case. The videos are up here, you can check. Then consideration should be of some value. Some value. Where it is not of value, the consideration. Then the consideration should be sufficient, not adequate. I can sell you a car of 10 million and you give me a bag of sugar. Sufficient. It should be sufficient, not adequate. Consideration should be sufficient, not adequate. Now, I hope I've tried to break down consideration. Unless you have a question, I can now look at the questions. If they are there, put down here in the chat, give us a thumbs up, and also put your question here. Any question, don't worry. Any question. If there's no question, I'm happy to say goodbye. But I'll wait for 5 minutes. If there are questions coming, I can answer any question. Don't worry. Any question. Any question. I am happy to answer it before I let you guys go. So we have said the rules. We have rule 1, consideration is no consideration. Rule 2, must come from the rule 3, performance of public duty. Rule 4, part payment of a debt. Rule 5, consideration need to be sufficient, not adequate. Rule 6, consideration must be of some. If you have no question in the next 2-3 minutes, I am happy to let you go and read. Any question from any students? I'm happy to discuss it now. I see you again tomorrow at 10. I see you again tomorrow at 10. Yeah. I see you tomorrow at 10. If there are no questions coming through, colleagues, I'll wait in a few minutes. Yeah, give us a thumbs up. Okay. Until next time, it was good having you. See you tomorrow at 10. I'll put up a few videos this night. You can always check out on our channel, subscribe on Voices of the Bar and Law School Made Easy. Those two are both our subscribe and keep the comments coming. Okay. Please hit on party subscribe. Yes, so please hit on party subscribe and defense and hit on party subscribe. Okay, now the first thing you must know when you are told about party subscribe is that, and this one you must write it. I don't know how, but it must be in your introduction. Find the rightful words. Now I'm going to use my funny English. Now, in commissioning of an offense, everybody thinks that the person who has committed the crime is the only one with it, forgetting there are many people who have liability that must be established. It is not only about the person who has committed the crime. Section 19 of the Penal Code, Cap 128, gives you the meanings of the different categories of people that can be liable when a crime has been committed. When a crime has been committed. Number one, principal offender, procurer, counselor, abater, aider, accessory after the fact, and joint offenders. You tend to forget joint offenders. So I'm going to give you the meaning of these people. Let us begin with the principal offender. A principal offender is someone who has actually committed the crime. That is one. Two, a principal offender can also be someone who has masterminded the event, even when is not the one who has actually committed the crime, but he masterminds the event. If you read that problem question and you see this guy is the one masterminding everything, he knows that this is coming from there. You see, he's the one with the plan. Even when he doesn't go to the scene, that guy is also a principal offender. A principal offender can be someone who has actually committed the crime, or it can be someone who has actually masterminded the commissioning of the crime. Counselor and procurer, these two, they encourage someone to commit a crime. The procurer goes ahead and even provide the material. But the distinctive factor about these two is very simple. They don't go to the scene of crime. So as you read your problem question, look out for those people who have not reached the scene of crime. Those two will be counselor and procurer. Aider and abater. These two, remember we said the counselor procurer encourage someone to participate or to commit. But aider and abater, they encourage the crime to continue. You understand the difference? Aider and abater, they encourage the crime to continue. And the distinctive factor is that aider and abetter, they reach the scene of crime. They reach the scene of crime. But let me discuss about the abetter. Abetter is that someone they tell, look up there, no one should find us, is abetting. The abetter can be someone who is saying, a police officer, an askari who is saying, me, I am paid to man this area. And then he sees people stealing the other bank. And he says, me, I got Equity Bank, they are stealing Centenary. I can't do a thing. He's also abetting. Aider is that somebody at the scene of crime helping. Give me that hammer, give me that this, send me that, giving knowledge, do this, do that. That person is aiding. I have said, a principal offender is someone who actually commits the crime or someone who masterminds the crime. Counselor and procurer, these are people who encourage people to commit a crime. A procurer goes ahead and provides material. And these two do not go to the scene of crime. That is procurer and the counselor. Aider and abetter, these two go to the scene of crime and they encourage the crime to continue. Accessory after the fact. That somebody who drives you away after you have committed the crime is the one we are calling accessory after the fact. That borderman or that taxi man you find on the way and you stop them. If you tell them you are from stealing and they don't go to police, they become accessory after the fact, even when they didn't know about your plans. But if you don't tell them about what you're from doing and you ask them to drive you to proceed, they are not accessory after the fact. Your wife cannot be accessory after the fact for protecting you, the husband. If the husband is from stealing and the wife protects the husband from police, the wife cannot be accessory after the fact. Let's go to joint offenders. Joint offenders. These are people with the common intention and the common purpose. In the problem question, look out for those people with the common intention and the common purpose. Those are the ones we call joint offenders. So tomorrow we shall have a session about the defenses at 10 p.m. So tune in tomorrow 10 p.m. We do the defenses and these other questions that you have asked. Some of them we shall handle them tomorrow at 10 in the night. I'll be here to do all the criminal law defenses. So let's meet tomorrow for the criminal law defenses. Until next time, thank you.